Thank you. I have just two more brief questions, and then I'm out of ammunition. One of Justice Stevens' explicit point that while in several states, notably Vermont, New Hampshire, and Pennsylvania, the state constitution's assertion of a right to keep and bear arms explicitly mentions that this is a personal right of self-defense, whereas the Second Amendment omits such language, although they clearly had it available, had such language available to them as an option, which which Madison deliberately chose not to employ.
I don't attach much significance to that either, because again, if we look back at the founding era practice, the use of these sort of prefatory clauses to contextualize or set the stage or just, essentially provide some kind of rhetorical throat clearing function was quite common. And I don't think it makes any more sense to ask why some state constitutional provisions included both an explicit reference to defending oneself as well as one's community, any more than we should ask why some state constitutional provisions included, like the one I read from New Hampshire, a recognition that the freedom of the press is essential to the security of the state, and others did not. The idea that we might, interpret some protections of free speech one way, depending on whether they did include such a prefatory provision, and then interpret other constitutional protections of speech in some different way because they happen not to include such a prefatory provision, is just alien to our approach to constitutional interpretation. And not only our approach, but this was black letter law at the time. So there were legal treatises at the time of the founding that explicitly told practitioners how to approach prefatory clauses and how to treat them and what their significance was, and that has remained consistent ever since then, which is that a prefatory clause is never interpreted to in any way limit or let alone undermine or cabin what follows. They've never been interpreted that way in any other context, and there's no reason to suppose that the framers of the Second Amendment intended that the Second Amendment alone be understood as, or the prefatory provision of the Second Amendment alone among all prefatory provisions that were common in that area be interpreted as having this highly constraining function. That would be extremely idiosyncratic, and there's just no evidence from the founding era that that was at all the significance or the understanding of such provisions. And I think it really just came down to largely a sort of a rhetorical choice of whether people chose to emphasize some particular justifications. But the idea that somebody might choose to emphasize one justification, namely, for example, we want to make very clear that the national government understands that the states have the ability, the individuals who reside within the states have the ability to arm themselves to resist national level tyranny, would in any way exclude or deny the possibility that that same amendment might have other reasons and other functions as well, besides the one explicitly mentioned in the prefatory text.
Thank you. Just one more. This is really a question, somewhat playful question, that your remarks have already indicated the answer to. But since I shared it with you already and enjoyed your answer to it in email, I'll ask it publicly. Was Federal Marshal Wyatt Earp in violation of the Second Amendment when he imposed his partial ban of guns in Dodge City?
He was in violation of the 14th Amendment, but it hadn't been interpreted. At that time, it had not been interpreted to protect any of the rights in the Bill of Rights, virtually all of which have since been incorporated. So technically, if Marshal Earp had forbade people from bringing books or even a Bible into Tombstone, Arizona, that would not have violated the federal Constitution as interpreted at that time. It was simply, at that time, it was simply understood that the Bill of Rights had no application as against state or local laws. And so it would be, I think, a serious mistake to draw any significance or to attribute any significance or draw any conclusions from that ordinance. I should add, by the way, that the weight of the scholarship on this issue, or I think my understanding of the weight of the historical scholarship is that the Earp brothers were basically a quasi-criminal gang that was involved in a conflict with another quasi-criminal gang, the Cowboys. And it happens to be that the Earps had the good fortune of sort of bringing themselves under the imprimatur or receiving the imprimatur of government authority. And so I think it was a very dubious exercise of political authority. And if you read the relevant history, it looks like the only people who were actually disarmed under this Tombstone Ordinance were people who were enemies of the Earp brothers, and it was understood that if you were on the side of the Earps, you were perfectly welcome to keep your weapons. So this was really more about a kind of a squabble among criminals or quasi-criminals at the time, and I would think it would be very dangerous to attribute very much significance to this provision. And as I said at the beginning, regardless of what the provenance of that particular ordinance was, it would not have been understood at the time as running afoul of the federal constitution. But then again, even would have a complete ban on newspapers or a ban or similar regulation requiring people to turn over their Bibles when they came into town might have offended the state constitution, but it wouldn't have had anything to do with the federal constitution as then interpreted by the Supreme Court.
Well, thank you, Mr. Neely. This has been a great pleasure for me, and I hope enlightening. I regret only that you're not here to share our dinner, perhaps on some future occasion.
I hope so. Thank you.
Sure, and we're not going to let him off the hook quite that easily. We have a set of other questions coming at you from the audience, and so we want to take time for that. I should mention that Mr. Neely has 2 children who had a snow day, and he's keeping them at bay until around about 6 o'clock we agreed to, but we may have to cut this a little bit shorter than that. In any case, we have a little more time. So before we open it up to questions from the audience, Clark, is there anything you wanted to add into all of that before we get going, or would you like to go straight to questions?
I'd love to go to questions, and I will preface it by saying I really appreciate the constructive dialogue, and I want to quote a philosopher friend of mine. He says this, I think, almost we teach together from time to time. He has a wonderful quote that I really take to heart, and I hope it helps to sort of convey my attitude towards opportunities like this to have thoughtful exchanges with people of goodwill. And what he says is, I have lots of beliefs, and I know that some of them are wrong, but I don't know which ones. And so I know that I have lots of beliefs, and I also know that some of them are wrong, and I don't know which ones are wrong. So it's incredibly, it's a real opportunity. It's a really valuable opportunity. Anytime you have the ability to have an open and honest and thoughtful exchange with people of goodwill. And so I want to thank all of you, even though I can't see all of you, and I really wish I were there, but I want to thank everybody in the room for that opportunity.
Okay, fantastic. Now we'll have a couple of Garfield scholars take the first stab at these questions. So Danny will go over there, and we'll have Jared go over there. More than ever, in this instance, it's always the case, but we always need you to turn on the mic in order for everyone to hear you. He will literally not be able to hear you unless you turn on the mic. So if each of you could turn on the microphone there, that would be fantastic. And then we'll start with Danny, and then we'll go to Jared. And then I'm sure a lot of you have questions. In fact, you started raising your hand there right from the beginning. So we'll get right to you here very quickly.
Hello. First, I'd like to thank both our speakers for being present tonight and presenting on this topic. My question is, in cases such as the Portland shooting and the shooting in Aurora, Colorado, the media reports on the identities and lives of these shooters, essentially giving them the coveted 15 minutes of fame. This has sparked many movements such as the notoriety campaign. In a time where mass shootings have dramatically increased, how do you think the media should continue to handle the identities of the shooters in order to not inspire more?
I strongly agree with the not referring to mass shooters by name. I do agree that many of them seem to be seeking a kind of notoriety. I make it a point not to use their names. I refer generally to the location where the tragedy occurred. So I think that's a sound approach, and I would encourage others to adopt it as well. One thing I would add is that it's not actually clear that mass shootings are on the rise. There have been more in the past few years than in former years, but it's not clear that this is a trend, or it's not clear that it's the kind of trend that people are afraid that it is. Of the roughly 37 or 38,000 deaths by firearms every year, more than 2/3 of them are in fact suicides. The vast majority of the remainder are homicides that are committed by people with a prior criminal record against other people with a criminal record, and only a very, very small percentage of deaths by firearms involve the kind of mass shootings that we read about in the paper, where someone just goes and kills a bunch of coworkers or family members or strangers. That doesn't make it any less awful or horrifying or tragic, but I think it is important to contextualize it and to understand that if you yourself are not, you don't have a mental health problem, you're not suicidal, and you don't spend very much time with people who are engaged in criminal activity, your chances of dying by gun violence are very, very small. And I would add one other thing, and that is, notwithstanding the terrible tragedies that we've seen in a number of schools, it remains the case that a school is the single safest place for a child to be. It's safer than the home, and it's safer than the car ride or the bus ride to and from the school. And I say that not really as an attempt to agitate in favor of any particular stance on guns or anything like that, but rather in an effort to reassure people that as horrifying and tragic as these events absolutely are, and as inexcusable as they are, and as important as it is to try to limit the number of them that happen, it is still the case that the likelihood of dying in a mass shooting is extraordinarily small, and a school remains a very, very safe place for your child to be.
Okay, Jim.
Okay, so thank you to both speakers for educating us tonight on this topic. My question is, do you think there would be merit in requiring a person to successfully complete a firearm safety and information course before allowing them to purchase a firearm? Why or why not? And this means
I'll leave it at that. So, yes, I think that we require young people to, I think in most states, or maybe in all states, young people are required to complete a driver education class before they can get a license. And in Texas, where I'm from, I don't live there now. I live in outside Washington D.C., but I was born in Texas and lived there for a couple of years. A couple of years ago, there is a requirement that before you can get a concealed carry permit, you have to complete a certain amount of training. It's the same thing here in Washington, D.C. You have to complete a certain amount of training. I'm not aware of any empirical evidence that it actually helps, but I'd be surprised if it hurts. And so I think it's unlikely to make much difference one way or the other. But if a sort of a democratic majority of people in a particular jurisdiction wanted to have that as a requirement before somebody could purchase a gun or receive a permit to carry a gun, I have no particular problem with it. I am skeptical whether it will actually do any good, but I don't have a problem with it.
I don't see any constitutional problem with the proposal.
Okay. All right, we'll open it up to the audience. If you could, we will need you to either approach a mic or I can repeat the question, whichever you prefer.
My question is just the definition. Is the right to own a gun or keep and bear arms, is that synonymous with the right to carry? I'm thinking of unlimited right to carry. Football stadiums, are there no constraints to carry?
So I Right, so there was an interesting argument in the Heller case about whether keep and bear arms should be understood as a kind of a unitary phrase, which was, as I recall, was Justice Stevens' position, or whether it made more sense to interpret the words keep and bear as being distinct, that the Second Amendment protects both a right to keep arms, which implies owning them and possessing them in one's home or perhaps also one's place of business, and then bear arms, meaning that it implies a right to actually also carry them around. You probably won't be surprised to hear that I favor the second approach. I do think the two terms are distinct. I think the case for the idea that keep and bear was essentially a kind of unitary term of art is not strong. And so, yes, I do think that the Second Amendment very clearly indicates a right not only to possess weapons at home and at one's place of business, but also to carry them around, at least under some circumstances. Now, there's a kind of an infamous passage in the Scalia majority in Heller where he goes out of his way to make clear that the decision should not be understood to cast any doubt on long-standing restrictions about bringing firearms into sensitive places, and I think he actually specifically lists post offices as an example, and maybe also schools. And so I think that we don't know for sure what the Supreme Court's take on this will be if a case goes up in the Supreme Court, for example, challenging some restriction. Let's say, I know there are some universities where students are permitted to carry weapons on campus, and there are some, I think the vast majority where they are not. One could imagine students at a university where they're not permitted to carry guns, challenging that if it went up to the Supreme Court. We don't know yet which way the Supreme Court would go. My guess would be that the Supreme Court would not find that there is a Second Amendment right to carry firearms on campus. I think it's a close call doctrinally, but my guess would be, at least as currently constituted, I'd be somewhat surprised if the Supreme Court found that there is a Second Amendment right to bear arms or to carry arms, for example, on a university campus. I could be wrong about that, and I think if there's yet another change in personnel on the Supreme Court in the near future, that could change. I should hasten to add, I wouldn't necessarily say I think that's a correct interpretation of the Second Amendment. Personally, I think the Second Amendment probably does protect a right to carry weapons in most places, with certain limits. I would agree. Obviously, you can't. I would say rather obviously, you couldn't bring. There's no constitutional right to bring firearms into a courtroom or into the White House or something like that. So it ends up being a line drawing issue, like so many constitutional questions are. Where the line will end up getting drawn, I think is too early to say. But very clearly, just like every other right in the Constitution, the Second Amendment has limits. And I fully expect that the courts will flesh out those limits in the coming years. And I think that the right of people to carry weapons outside of their home will be very narrowly constrained, and pretty much wherever a legislative body or a city council or other sort of democratic or political body says they don't want people to carry weapons, more often than not, I expect the courts will go along with that.
Well, yes. The question that you asked, David, is two questions, or at least it invites two questions. One is, does the court's reading of the Second Amendment, specifically the terms keep and bear arms, mean carry? The answer to that is yes, it does. It was a point of disagreement between Justice Stevens and Breyer on one hand, and Justice Scalia on the other, and Justice Scalia gives the opinion of the court. The other question is, where might one carry the arms that you are allowed by the Constitution to carry? And that is the sort of question which, as we said at the very outset of our conversation, has to do with the reasonableness of the regulation. Those questions are now questions of the sort that can come to the court because they are not precluded from coming to the court in a way that they would have been had the Heller case gone the other way.
Next question.
Sort of a two-part question. I wanted to know if either of you were aware of the historical record at the time the Second Amendment was adopted, or anywhere in the jurisprudence since then there was any acknowledgement that the framers intended the right to be lesser than that of the national army that they feared, the firearms and what arms they thought the citizens could possess. Because at that time, firearms were relatively new. I imagine there wasn't much difference. Was there, for example, anything in the historical record that intended they didn't want them to have cannon and shots and all of those things? And then juxtapose that fast forward to where we are now. In modern times, they couldn't have imagined the weapon we have. We all agree they shouldn't have nuclear bombs, because and tanks. It wouldn't work in society. Is there anything in the record that supports that argument? When did that line get drawn in the jurisprudence record? I haven't seen anything except for dicta where they talk about common use. And when does common use become not so useful if the goal is to resist tyranny? And so that's kind of where I'm at. Is there anything in the record that would have said the Congress supported limiting the rights of firearm ownership to certain types of weapons that don't kill kids in school, that aren't useful in mass shootings in Las Vegas? They didn't comprehend that back then. So where in the record do we create that? And my final thought is, would the appropriate place to remedy that be the amendment process in the Constitution? Why does nobody talk about that? And when we look to the courts for our solution to the problem, but I think this is the only amendment where the ultimate solution eliminates the right, and I think the only appropriate constitutional way to get there is through the amendment process as laid out.
I guess I'll start. I don't think there's any reason to believe they gave it very much thought in terms of exactly what weapons would or wouldn't be protected. There's historical practice seems to be that people actually private owners owned cannon back then. It was not at all uncommon to have the owner of a ship. There were private armed warships. There's a provision in the Constitution that authorizes the federal government to issue letters of marque and reprisal. What that means is authorizing private ship owners to go out and hunt down pirates and enemies of the United States. And the way they would do that was with very heavily armed ships that had cannon on them and very powerful weapons that would be in private ownership. Now, does that tell us whether or not the framers of the Second Amendment intended that the Second Amendment be interpreted to protect the ownership of our artillery pieces? No, we have no idea. Was it common back then for private individuals to own that kind of weaponry? Yes, it appears to have been. I'm skeptical how much light that really sheds on sort of current issues. What I would say is this. I think it's abundantly clear that the Supreme Court will interpret the Second Amendment as not protecting sort of truly military class, non-private weapons, or weapons that don't associate with private ownership. The U.S. Supreme Court is never going to hold that the Second Amendment protects the right to own a tank or a rocket launcher or a hand grenade, or frankly, even a fully automatic weapon, or what's commonly called a machine gun, even though I think probably the better historical interpretation of the Second Amendment is that it would, properly interpreted, it does protect the right to own a fully automatic weapon or a machine gun. The odds of the Supreme Court ever interpreting the Second Amendment as providing such protection are as close to zero as you can get, and let's just call it zero. The Supreme Court is never going to protect or interpret the Second Amendment as protecting the right of private individuals to own weapons that we associate uniquely with the military. The furthest they might go would be to strike down some of the so-called assault weapon bans that have been popping up. But even those, I'm quite skeptical whether the Supreme Court is going to go back with them. So to go back to where I started, virtually any gun regulation that pro-gun regulation people can persuade a Democratic majority of their fellow citizens to support and enact is going to be upheld by the courts. That's my prediction.
Well, I would agree with that. Let me see if I understand the thrust of your question, though. I take the question to really contain the suggestion that what we need is an amendment to the amendment so as to define the term arms.
Yeah, I just think we've ignored it for so long, and the debate has evolved now into, hey, that stuff kills people. That's what the amendment's for, is to protect these devices that are capable of death. So we're in two polar opposite places, and we seem to think the courts are going to resolve it, but you get all these different results depending on where you live, and what you can own, and what you can have in your home, and what you can take anywhere.
Well, that's
Why
right.
don't we talk about amending
However, while your suggestion, the suggestion that's contained in your question is tempting, abstractly tempting, my mind begins to boggle in thinking about how we might actually undertake it, to define arms in a way that still preserves some force in the amendment and at the same time makes it safer. Is a task that I would guess exceeds the genius of the American public or any advisor to it. Fundamentally because any kind of weapon can be dangerous in that it poses the prospect of insurrectionary or civil violence.
I believe the next question is over here.
Yeah, is this working? Okay. I'm going to ask you, Mr. Neal, to bring this into a sort of a messy future rather than in the theoretical historical past of interpretation. There are members of our Congress who would wish to ban various weapons, types of weapons, from the United States and make it illegal for any person, private citizen, to possess them, such as you mentioned earlier, assault weapons or possibly automatic, semi-automatic weapons that could be used in a semi-military style or for target shooting on private use. If in the unlikely and remote possibility that the House of Representatives would draft such legislation and pass it, and send it on to the Senate, which would agree to it, and some president would sign it, what would be the essential components of such legislation, in your mind, which would be a sort of sine qua non of such legislation that would make it pass a constitutional test?
So I think I don't think we can really predict where the Supreme Court might draw the line if the Congress tried to very substantially restrict, basically to ban some class of weapons. Let's make it concrete and say that Congress passed a law that banned the possession of what are commonly referred to as assault weapons, or kind of AR-15 semi-automatic rifles that figure in so many of these tragic mass shootings. I would really hesitate to predict what the U.S. Supreme Court would do with that. I think it could go either way. I think there's an underlying dynamic here that's important to keep in mind, because I think it might influence the judiciary's response. Contrary to what a lot of people might think, there really has been no serious effort to enforce most gun laws. One of the sort of the deep, dark secrets of gun regulation is that gun regulations are one of the most widely ignored laws in the country. They're right up there with drug laws. For example, there was a Department of Justice study that looked at gun ownership in New York City. There are about 50,000 lawfully registered firearms in New York City. The U.S. Department of Justice estimates that there are about 2 million guns in private ownership in New York City. So 50,000 lawfully licensed firearms in New York City, but about 2 million illegal guns. And that repeats itself in not just in virtually every jurisdiction in America, but it also turns out to be the case in Europe. There have been a number of studies in France and Germany and elsewhere that shows that the number of firearms in unlawful or illegal possession vastly outnumbered the number of lawfully owned firearms. And here in America, there's actually very, very little effort to enforce gun laws, including in states like New Jersey and Connecticut and New York that have recently, banned things like high-capacity magazines and assault-style weapons. These laws tend to be sort of pure symbolic and window dressing in the sense that there's no serious effort to enforce them. And so if the Congress were to ban, for example, a particular kind of assault weapon, but then, as has been customary throughout our history, there was no serious effort to enforce that law, then I think the courts might be more inclined to sort of take a hands-off approach. Basically as long as not a very significant number of people, as long as you can be reasonably safe in ignoring the law and getting away with it as you can today, then maybe the courts would be somewhat less inclined to get involved. But if there were a serious effort to enforce that law, and if a significant number of peaceful, otherwise law-abiding people were being sent to prison simply for owning a very common firearm like an AR-15, and that is one of the most common firearms in private ownership in America today. If there were, contrary to historical practice, a serious effort to enforce that law, and if a significant number of people started being incarcerated for violating that law, then I think it's more likely the courts would get involved. But I think the likelihood of such a law being passed is relatively low, and I think the likelihood of such a law being enforced in any meaningful way, even if it were passed, is virtually zero. So I don't think it's likely the courts would have to get involved, simply because even if such a law were passed, people would just ignore it the way they do today, and the government would decline to enforce it in any serious way, just the way they have with other gun laws, that are similar.